Welcome back to the Dershow. Most people remember the Shakespearean line from Henry VI, Part 2, where he has the great villain say, the first thing we do, let's kill all the lawyers. People misinterpreted that as something Shakespeare would have wanted. No, it's even possible Shakespeare was a lawyer, we're not sure, but Shakespeare put it in the mouth of one of his most villainous characters. And of course, that motto has been followed. One of the first things Putin did was kill the lawyers. Remember that there was this very prominent person who was opposing Putin, and he had a lawyer named Magnitsky, and Putin killed him, sent him to jail, and then had him killed. Mao Zedong put the lawyers in pig farms. He didn't kill them, but he took them out of the game. Stalin killed the lawyers. Hitler killed the lawyers. Now what we're seeing happening is the Get Trump gang has decided to focus on lawyers. They've decided to indict lawyers, name them as unindicted co-conspirators, have them sanctioned, have them subject to disbarment. The attack on the lawyers is part and parcel of the attempt to get Trump, because without lawyers, without effective lawyers, without zealous lawyers, without lawyers who are prepared to put their friendships and reputations on the line, the way I unfortunately had to do when I defended President Trump against his first impeachment on the floor of the Senate, losing my friends on the Vineyard, having the library ban me and my books, having book fairs stop having my books, and my synagogue banned me, Temple Emmanuel in New York banned me. Going after the lawyers is a very, very effective way of getting Trump. So, Get Trump's Lawyers is the possible title for my next book. And it's a serious effort. If you look at the indictment in Georgia, it names several lawyers. One of them is particularly interesting. His name is Kenneth Cheeseborough, and he's the defendant who recently asked for a speedy trial, really discombobulating the prosecution, because they want to try everybody together. You know, the district attorney of Fulton County mendaciously told the public that she would want to try all 19 defendants together within 6 months. Absurd, impossible. And Cheeseborough, who's apparently a very good lawyer, put her to the test by demanding a speedy trial under the Georgia statute, and it's mandatory. So he got it. Now his trial is set for a couple of months from now, which means that other defendants either will have to be put on trial in a couple of months, which is impossible, or they will have to be severed, which gives the defense considerable advantage, because it means they have a chance to forecast and see and preview the government's case before Trump, for example, goes on trial. Now that trial is scheduled in March. March is trial month. 3 trials of Donald Trump scheduled in March and 1 in May. One of them for the day before Super Tuesday. We talked about that yesterday, and I'll get back to some of those issues today. But today I want to focus on getting the lawyers. Now, there are a lot of ways of getting lawyers. You indict them, you name them as unindicted co-conspirators. Jack Smith in the Washington case was cleverer than the DA in Fulton County. The DA indicted them, and they seemed like extremely, extremely weak indictments. But that's not what happened in the District of Columbia. In the District of Columbia, Jack Smith simply named them as unindicted co-conspirators. That's very clever, a little sneaky, and a little dirty pool, because it means that these people probably can't effectively testify on behalf of the defendants, because they're named as unindicted co-conspirators. That is essentially they're accused without being indicted of similar conduct. So if Donald Trump, for example, were to say, well, I relied on Cheeseburger's advice, the response would be, yeah, but he's an unindicted co-conspirator. He's just as bad as you are. We just haven't indicted him. So that's one way of getting lawyers. The other way is the 65 Project, which has been, unfortunately, fairly effective. 65 Project is a group of radical left lawyers, and some not so radical left, but all have in common get Trump. And borrowing from the McCarthy playbook, they've basically said if anybody dares to represent Trump, if anybody dares to represent anybody associated with Trump, we're coming after you. We're going to file bar charges against you. We're going to file sanction motions against you. We're going to try to get you disciplined and disbarred. Immediately when that happened, I think I mentioned this before, I wrote an op-ed calling the 65 Project a version of McCarthyism, the new McCarthyism. So what do you think they did? They filed a bar complaint against me in Massachusetts, and now I have to spend my hard-earned money retaining lawyers to defend me. I didn't do anything wrong, but nonetheless, I have a bar charge against me. So that means I can't appear in other states because to appear in other states, you have to file a motion, and those motions are often denied if you have a bar charge, even if it's an unresolved bar charge against you. I've never been found guilty of a bar charge or anything like that, but nonetheless, there's an open bar charge. So that effectively stops me and others who against whom this tactic has been used from defending Trump, even if I wanted to or were able to, or defending some of the other defendants. One of my close friends is defending one of the lawyer defendants in the case, and coming up with some fairly sophisticated legal defenses. I mean, do you really indict lawyers for giving legal advice, even if the legal advice turns out to have been rejected by the court? That's what happened, of course, in Bush versus Gore. I was the lawyer representing the voters of Palm Beach County on the notorious butterfly ballot, which probably cost Gore the election. We filed all kinds of motions, and Gore's lawyers, led by Lawrence Tribe and David Boies, filed all kinds of motions. Every single one of them lost, and lost pretty decisively. In the Supreme Court, it was only 5-4, but there were other cases as well where they lost. And they proposed all kinds of very radical steps. Tribe wrote an article and memorandum in which he said, well, you can have a recount up to January 6th, up until the day the election is certified. He said you can do that under Florida law, but if you can do it under Florida law, you can do it under the law of any other state that permits it. What he said is the Constitution essentially permits a challenge until January 6th. And that's precisely what Cheeseborough, who ironically was his law clerk and was his research assistant, at the time he made these arguments, and now Cheeseborough borrowed some of the arguments from Tribe. Tribe says, oh, I didn't say that. Yes, you did. Yes, you did. Just read the law review article and you'll see you did say that. But he says he didn't. And Cheeseborough has now been indicted in Georgia and named as an unindicted co-conspirator, we think. Unnamed, but we think that he's one of them, who was named as an unindicted co-conspirator in Washington, D.C. Get the lawyers. Get the lawyers. If you can get the lawyers, you can get the client. And that's the tactic that's being used. It was the tactic that was being used during McCarthyism. I remember, I'm 85 years old, so in 1955, when McCarthyism was pretty much at its height, I was a freshman in college, and I became president of the student government at Brooklyn College, which had been called the Little Red Schoolhouse because it had been, all the city colleges in New York had been a center for communist, socialist, radical, anarchist activities. And I was the president of the student government, and I had to defend the right of teachers who I thoroughly disapproved of, disagreed with, and would never take their courses, who were communists or fellow travelers or socialists. very against communism, obviously. But I defended them, and I was, as a result of it, the president of the college, the university president, wouldn't recommend me to law school, wouldn't recommend me for a Rhodes Scholarship. He said that he thought I was a communist, much the way some people think I'm a Trump supporter. I'm sure John Adams, people thought he was a supporter of the British because he defended the soldiers at the Boston Massacre. No, we're lawyers. I'm an anti-communist lawyer who defends communists. I'm an anti-Nazi lawyer who has defended the right of Nazis to speak. I'm an anti-PLO lawyer who defended the right of students at Harvard to fly the Palestinian flag and to have a memorial for Yasser Arafat. Of course, at the memorial, I said I thought Arafat's death was untimely. I wish he had died 4 or 5 years earlier. There might have been a two-state solution. So I'm no stranger to defending people who I don't approve of, don't like, and don't support. But most Americans still don't understand it. I still get, I would say, 10% of my emails are, how can you possibly defend Donald Trump and not vote for him? Half of that says you should vote for him, and the other half says you shouldn't vote for him or defend him. But almost none of them say, wow, it's really interesting. You don't vote for him, you want to see him beaten, but you defend him. But that's the American way. It's not the McCarthyite way. Under McCarthyism, if you defended somebody, you were labeled a fellow traveler. You were labeled a sympathizer. You lost your job. You lost your opportunities as a lawyer. Judges discriminated against you. The Harvard Law Review kicked off a man named Lobel. I still remember the name. This goes back now, 60, 70 years, because he had been accused of being a communist in the 1930s. He had the best grades. He made the Harvard Law Review, but the Harvard Law Review in a McCarthyite act tossed him. That's what McCarthyism was, and we're seeing a renewal of McCarthyism now in the Get Trump posse. And the Get Trump posse is going after the lawyers. And I'm hoping that the lawyers, I'm hoping everybody has zealous representation. That's the way the American system works. It works best when you have an adversarial system with equal talents on all sides. And so it's not the lawyers who determine the outcome of the case, but it's the facts and the law, because lawyers on both sides are zealous advocates. I hope there'll be zealous advocates, but I don't think there will be. I can tell you, I know lawyers who have declined an opportunity to defend Trump and some of the people that have been charged with Trump because they're afraid Project 65 will come after them. They're afraid they'll lose their friends the way I did. They're afraid they'll lose their jobs. They'll lose their clients. There are law firms. I spoke to one yesterday that refuses to represent anybody who has anything to do with Donald Trump. That's their politics. But it's not the American way. And the American way is you defend people who need representation without regard to their political views, their ideological views, and their partisan affiliations. Unfortunately, we're becoming more like some European countries where there's a left-wing bar and a right-wing bar, and the people on the left only represent people on the left, and people on the right only represent people on the right. That was different in America for many, many, many years. We had a tradition. Ed Bennett Williams, who was a strident Democrat, very friendly with people on the Democratic Party. He represented Republicans. He represented communists. He was himself a very religious Catholic. He represented atheists. He represented people who he fundamentally disagreed with. Abraham Lincoln did the same thing we all know about. John Adams, Daniel Webster did the same thing. Thurgood Marshall represented people he disapproved of. Justice Ginsburg made a career out of defending men who were discriminated against in order to establish principles which would make it harder to discriminate against women. She was very smart that way. And some of the most important cases involving anti-discrimination against women were established by male plaintiffs. And so I remember I had such a case. I had a case where somebody came to see me. It ultimately, Massachusetts had a very important case where a man who was a nurse was married to a surgeon. A woman was a surgeon, and the woman ran off with another doctor. He had paid for her medical school, and he wanted alimony. He had no money. He was a nurse. He was making, a small amount of money. She was a surgeon making a fortune of money. He had paid for her medical school, and so he wanted to get her to pay a substantial alimony. And he went to a firm that specialized in getting good alimony payments for women. And the head of the firm said, no. We don't represent men. We only represent women. And he brought a lawsuit. And Massachusetts courts upheld his lawsuit, saying, you can be a feminist, but you can't be a sexist. That is, you can take cases that help feminism. In this case, would have helped feminism because it was a case claiming that the poorer person who put the richer person through medical school has to pay money. But you can't be a sexist. You can't have a sign on the door saying, no men, no Jews, no Muslims. And I don't think you can say, I don't know whether the law would support this, but I would say you can't have a sign on the door that says no Republicans, no Democrats. Lawyers should represent anybody, regardless of their politics. I was asked to represent a man once who was a neo-Nazi, but he had been denied admission to the bar because of his views. And I agreed to defend him, but I said I would charge him my full fee, and I would donate all the money he paid me to the Anti-Defamation League of the B'nai B'rith and to the NAACP, and he wouldn't give the money to them, so he didn't retain me. I'm very lucky because a few months later he was charged with facilitating the murder of some Jews and blacks, and went to prison for a long period of time and threatened my life. And I had to have FBI guards defending me for a period of time when it looked like he had a hit out on me. That's what real lawyers do. They defend people they don't like. They defend people they disapprove of. They defend principles, not people. Again, the Bible, I've told you this so many times, but it's my favorite portion of the Bible, my own bar mitzvah portion, Shoftim, Judges. And the first lesson to judges is Lo Takir Panim, do not recognize faces. Do not do justice based on who the person is. That's an instruction to judges. I taught my students the same thing if you're a lawyer. If you're a lawyer, don't recognize faces, don't recognize races, don't recognize genders, don't recognize sexual orientations. Take cases that are important for the Constitution without regard to who the person is. That's where the statue of blindfolded justice comes from. It doesn't come from Greek mythology. It comes from the Torah, from the Bible, from a book holy to Jews and Christians alike. I would bet you that other holy books, Quran and other holy books, probably have similar admonitions to do justice without regard to the person or the political party or the gender. But that's not the world we live in today. We live in a world of identity politics, where not only do courts recognize faces, they make their decisions based on races. Supreme Court finally said no when it comes to university admissions. We'll see what happens, whether or not universities cheat to get around that decision. But finally, the courts are saying don't recognize races, but too many people in too many contexts still do. Going back to the lawyers, something has to be done about this. And the tragedy is, during McCarthyism, there were a group of at least courageous lawyers who stood up to the attempt to try to use getting lawyers as a way of denying people's civil liberties. I don't see that group today. I don't see that group emerging. I don't see principled lawyers today getting together and saying, we don't like Trump, maybe we don't like Dershowitz, we don't like any of those people, but we're going to stand up for the right of every citizen to be represented by a zealous lawyer. We're not going to let the Get Trump people use the legal profession as a way of getting Trump. We're going to stand up against that. Lawyers, where are you? Why aren't you speaking? Why are you silent? Are you being intimidated by the 65 Project? Are you being blinded by your hatred for Trump? No, speak out. You're the last barrier between governmental tyranny and the people. That's why Shakespeare said the first thing we do is kill the lawyers. That's why Mao put them in pig farms. That's why Putin killed lawyers. And that's why people like Abraham Lincoln and John Adams and Thurgood Marshall and Edward Bennett Williams and Louis Brandeis and Arthur Lyman and James St. Clair. Some of these names are known to you, some of these are not. James St. Clair was a lawyer who represented Nixon. He didn't like Nixon. I didn't like Nixon. But I remained Jim's friend because he did a terrific job. I remember once being asked, would it be a good thing for Nixon to be represented by Jim St. Clair? And I said, if he's innocent, it would be a great thing. If he's guilty, maybe not so good. And so I said the same thing about a number of other special counsel that were appointed over the years. So this get Trump's lawyers thing poses an equal danger to get Trump. And I'm going to stand up against it with all my power and might, as long as the good Lord gives me the energy to keep fighting back against injustices, regardless of whether they come from the left or the right, from Democrats or Republicans, principled, constitutional. That's what matters. Okay, let's look at some letters. The DC judge fast-tracking the case and expecting defense counsel to read through millions of pages of exculpatory evidence is in conflict with Rule 1.1 of the Model Rules of Professional Conduct. Right. That states, a lawyer shall provide competent representation to a client. Competent representation requires legal knowledge, skill, toughness, and, this is the point, preparation reasonably necessary for the representation. If I were the lawyers in that case, I would bring this into court and say, Your Honor, I cannot comply with Rule 1.1 of the Model Rules. I cannot do thorough preparation reasonably necessary for the representation in the short amount of time you've given me. So with all due respect, Your Honor, I'm declining this case. I can't do it. I can't do it. You're going to have to find another lawyer who's willing to compromise on preparation. Already, the judge and the prosecutor, we don't have to read every page. Yes, you do, because we know the trick prosecutors use. Needle and haystack. They have 12.7 million pages. They throw it at you. It's called a document dump. And they say, look through it. Maybe you'll find the 10 or 15 nuggets that will help you win the case. That's not the way it should be. Prosecution should be required to identify the critical pieces of exculpatory evidence and point them out to the defense so that the defense doesn't have to rummage through 12 million pages in order to get to the 1 or 2 or 10 or 100 pages that really matter. It's a trick, and it shouldn't be tolerated by the court. One of the letters reminds me of an old quote. It used to be said that the wheels of justice turn slowly but grind exceedingly fine. I want to return to that time period. Look, it's true. Justice to be served is, it takes time. And I'll just read you a couple more letters along those lines. I have worked for the U.S. Attorney's Office, and I have never, ever seen a defendant facing so many trials in such a short period of time. Not mass murderers, not serial killers, not lifelong mobsters, none, ever. Prosecutors have always consolidated cases to focus on the most egregious charges they are bringing and bringing it at one trial. This is ridiculous and has no precedent. In addition, defense always is given more time and leverage in any case or trial. What's going on here? What's going on here is get Trump. And you're absolutely right. In a normal case, the judge would say, particularly in the Georgia case, well, wait a minute. Let's just figure out what you're really charging here. Do you really need RICO? I don't think you need RICO. And do you really need all these defense? I don't think. Let's narrow the focus here. Judges do that. If the prosecution won't do it, the judge can't make them do it. You have to give them more time to prepare for complex cases. I was a defendant in Morris County, New Jersey. I was indicted in March 2008. March 2008. I didn't go to trial until March 2015. 7 years later, where was the state asking for a speedy trial there? On the white collar crime. Only 15 boxes of discovery of ham sandwiches, and you want to tell me Trump case scheduled for March? Unbelievable. I need someone to call me. I need to go on TV. Well, you're not on TV, but you're on my podcast, and your name is Adel Mikhail. Okay, so you're on a version of TV. Question: if they are forced to go forward in 6 months, can Trump then claim, among all other claims he will have, ineffective counsel? And could his attorney testify in his defense that they were ineffective due to time constraints? What would be the downside or repercussions, if any? No lawyer could do that. If a lawyer feels that he was denied the opportunity to represent his client zealously and effectively, the lawyer can appear as a witness. Now, when the lawyer appears as a witness, that may constitute some kind of waiver of lawyer-client privilege communications. They would have to sort that out and get what are called motions in limine decided by the judge before he made that decision. But yes, I think if they are forced to trial, and if the defendant is found guilty, he can, and I'm sure will, appeal. The next question relates to that. Is there any way to appeal the scheduling of the trial on the grounds that there's no way a defense can digest the discovery and prepare a defense in that time frame? Yes, there is. You can bring a writ of mandamus. You can bring an interlocutory appeal, and you can try to get the case up before an appellate court on this issue. There's no guarantee the court will take it, but you can at least try. And I would think that the defendants in this case would have a good case to bring to an appellate court, particularly when you have to read, 12 million pages in 6 months. I think that would be something a court would be sympathetic to. And courts have to be guardians of due process, not the ones who are denying due process. This judge is basically saying, you don't have to read that stuff. Come on, that's just stuff. You don't have to read that stuff. Yeah, you got to read that stuff. You got to do your homework. Your Honor, you may not have to read that because you have a law clerk. But I, as a defense attorney, I have nobody to read it for me. I have to read it. I don't trust young kids right out of law school to make very complex and very subtle decisions about how to use a piece of evidence that might be exculpatory if used in a certain way and inculpatory if used in another way. I'll give you an example about that. Take the famous phone call that is the subject of this indictment, really both in Georgia and implicitly in D.C. as well, where President Trump tells Raffensperger, the Secretary of State, I need to find 7,000, whatever the number was, votes. That can be seen as exculpatory or inculpatory. The exculpatory meaning is he said find. He didn't say make up. He didn't say concoct. He didn't say manufacture. He said find. And find means it's there. And if it's there to be found, it's appropriate. I guarantee you that people on the Gore defense team, Tribe, or some of the others, I guarantee you they made phone calls. And they certainly, among themselves, said, can't we just find 600-700 votes? If we have a recount in this county, but not that county, maybe we can get 200 there, maybe we can get 300 there. I assure you that conversation occurred. And so handled properly, the Raffensperger call can be deemed as exculpatory. Handled improperly, it can be seen as inculpatory, as incriminating. All right. This is an interesting question. If lawyers were to wait until the last minute and then step down, would the judge give a continuance if President Trump doesn't have a lawyer? Well, once you make an appearance in a case, you can't step down. The judge will say, you're ordered to defend the case. I don't agree with that. As a teacher of legal ethics for 30 or more years at Harvard, I would refuse to participate in a trial in which I could not provide zealous, effective representation to my client. if my performance would be ineffective assistance of counsel, I won't do it. Just like I wouldn't perform an operation if I were a doctor unless I had all the x-rays, all the CAT scans, all the papers. I wouldn't accept a statement from the chief of the hospital. Oh, you don't have to read them all. Come on, just do the surgery. You know enough. You have a lot of experience. You can do it. You don't have to read all the CAT scans and all the pharmaceuticals. Come on. No doctor would ever do that. And no lawyer, no good lawyer should agree to represent a client under the circumstances